sentencing in this matter. This one is you should change your word. The court calls the matter of people meaning for the district attorney. People meaning district attorney. Versus Thomas Edward Lawrence. Thomas Edward Lawrence meaning defendant. Case number 8992034. Is the defendant ready for the sentencing in this matter? Which you should do. And then J meaning judge. Are the people ready? Are the people ready? DA meaning district attorney. Yes, Your Honor. The people are ready. The people are ready. District attorney ready. And then judge, Mr. Lawrence. Mr. Lawrence meaning the defendant. Mr. Lawrence, have you read the probation report, or has the probation report been read to you? PD meaning Your Honor. The defense will stipulate that the probation report has been interpreted for the defendant and he has no additions or corrections. He is willing to adhere by the recommendation contained therein. J meaning judge, DA meaning district attorney, PD meaning defendant. J, are the people agreeable to the stipulation? D, so stipulate, Your Honor. Judge, is there any reason why sentence should not now be passed? PD, no, Your Honor. 다시, Judge, very well. In case number 8992034, imposition of sentence is suspended and the defendant is placed on formal probation for 5 years with the following terms and conditions. Number 1, that the defendant spend 90 days in the county jail. This is a judge. The first one, that the defendant spend 90 days in the sentenced county jail. Number 2, that he pay a fine in the amount of $980 plus penalty assessment of $450 plus the $50 proceeding fee, the work for meaning he should go to jail, but daytime should go to work, and the nighttime should go to jail. So interesting sentence, work for. If he qualifies for a total of $1,480 on or about July 14, 1994, if we wish to make that payment is monthly installment, there will be an additional fee of $30, and the minimum monthly payment is $50. This is the court action. Judge make the sentence. Number 3. Normally, any other interpreters, one line, judge or district attorney, some say, but normally sentence should interpret simultaneous, not judges not wait, and then simultaneous same time we should do. Number 1, that the defendant spent 9 days in the county jail, and then your country word that the defendant spent 9 days in the county jail. Number 2, that he paid a fine in the amount of $980 plus penalty assessment $450 plus the $50 processing fee for work photo. If you qualify for a total of $1,480 and or before July 14, 1994, if he wishes to make for payment the penalties. Number 3, that he's not drive with any measurable amount of alcohol in his system. 4, that he's not drive without a valid driver's license. Number 5, that he submit to drug tested whenever to requested by his probation officer. Number 6, that is attended and complete number 6, that is attended and complete the residential drug treatment program recommended by his probation officer. 7, that he's not associated with the very noun Number 7, that he's not associated with any known member of any gang. Number 8, that he not molest, harass, or in any way communicate with his ex-wife and children. Number 9, that he performed 20 hours of community service. Mr. Lawrence, do you understand each and every one of these terms and conditions of probation? Yes. This is a sentence. Next page, 18. Are you willing to adhere by them to the letter because it you are not. You got a prison sentence hanging over your head. Do you understand? Yes, sir. That will be the order of the court then. Good luck to you. This is simultaneous the interpretation. You getting just to read and then your country word change it. To read your country word is change it. Everyday lesson, and then you can do it. Easy interpreter. Interpretation the first time is so difficult, but not difficult, so easy. One line, one by one, you lesson, and then to change your word. That's easy. You're trying to. Oh, God. You review that the one line English and your country word. Your country word is Chinese?
No, Japanese.
Oh, Japanese.
Yes.
Oh, okay. One by one. Japanese not much for the interpreter in the court.
Yes.
Yeah.
And hard to see them.
Uh-huh. Yeah. If you ready for the interpreter, that's so easy interpretation in the court work. One line, read, and then one line read English, and the one line your country word. One by one. And the exercise you can do easy way. Page 19, we do that the interpreter. One line, read English, and then one line, you make your line, your country, and then exercise one by one, and then you can do the easy interpreter. Interpreter is the simultaneous, and then to simultaneous is me, and then consecutive. Okay. Number 19, page 19. Simultaneous lessons, direct and circumstantial evidence. Direct and circumstantial evidence. Evidence consists of testimony of witness, writings, material object, or anything presented to the sentence, and offer to prove the extent or non-extent of a fact. This is the English one line, and then your country word, your word, one line exercise. Evidence is either direct or circumstantial. Direct evidence is evidence that directly proves a fact without the necessity of an inference. It is evidence which by itself, if found to be true, establishes that fact. Circumstantial evidence is evidence that, if found to be true, prove a fact that which is an inference of the inference and existence of another fact may be drawn. An inference is a deduction of a fact that may logically and reasonably be drawn from another fact or a group of facts established by the evidence. It is not necessary that fact he proved by direct evidence. They may be proved also by circumstantial evidence or by a combination of direct evidence and the circumstantial evidence. Both direct evidence and the circumstantial evidence, and except as a means However, finding a guilty as to any crime may not be based on circumstantial evidence unless to prove circumstances are not only consistent with the theory that the defendant is guilty of the crime, but number two, cannot be reconciled with any other rational conclusion. Further, each fact which is essential to complete a set of circumstances necessary to establish the defendant's guilt must be provided beyond a reasonable doubt. In other words, before an inference essential to establish guilt may be found to have been provided beyond a reasonable doubt, each fact or circumstance upon which is such inference necessary must be provided beyond a reasonable doubt, as it also, if the circumstantial evidence as to any particular consent is susceptible of two reasonable interpretations, one of which point to the defendant guilty and the other to be innocent. You must adopt that interpretation which point to be defendant innocence, and subject that interpretation which point to his guilt. If, on the other hand, one interpretation of which evidence appears to you to be reasonable and the other interpretation you must accept the reasonable interpretation and reject unreasonable. Next one, number 20. But one person is coming late time. 17, page 17 again. We do 17, page 17, simultaneous lesson. Direction the interpreter into your target language. Your target language meaning your country word. J meaning judge. PD meaning defendant. DA meaning district attorney. 자, one by one, they're gonna quote, they say, J, 17J, the court calls the manner of a people meaning district attorney. Manner of people versus Thomas Edward Lawrence. Thomas Edward Lawrence meaning defendant. Case number 899-2034 is the defendant ready for the sentencing in this matter? Judge say, opening the matter. PD, Your Honor, my client informed me that he is ready for you to pass sentence based on the probation report. Attorney of defendant. J. Are the people ready? Are the people ready? People ready meaning district attorney. District attorney ready? District attorney. Yes, Your Honor, the people are ready. 판사. J. Mr. Lawrence, have you read the probation report? Or has the probation report been read to you? PD, Your Honor, the defense will stipulate that the probation report has been interpreted for the defendant and he has no additions or corrections. He is willing to abide by the recommendation contained therein. J. Are the people agreeable to that stipulation? D. Yes, stipulate, Your Honor. J. Is there any reason why sentence should not be the past? PD. No, Your Honor. Judge gonna make a decision very well. In case number 899-2034, imposition of sentence is suspended and the defendant is placed on formal probation for 5 years. It's the following terms and condition. This line, judge gonna do sentence. This line should the interpreter simultaneous, not consecutive. Judge is not gonna give any chance. Should do simultaneous. For line, very well, in case number 899-2034, the same time interpretation, simultaneous lesson. Imposition of sentence is suspended and the defendant is placed on formal probation for 5 years with the following terms and conditions. PO 5 years probation. Number one, that the defendant spending 90 days in the county jail. Number two, that he pay a fine in the amount of $980 plus penalty assessment of $450 plus the $50 processing fee for work photo. Work photo meaning should go to jail just nighttime only. Daytime should go to the work, and the nighttime or the weekend he should go to the jail. That is work photo. If he qualifies for a total of $1,480 on or before July 14, 1994. If he wishes to make that payment in monthly installments, there will be an additional fee of $30, and the minimum monthly payment is $50. 3. That is not drive with any measurable amount to alcohol in his system. Maybe he getting some drugs. Maybe he getting the problem is the what's that? Alcohol sentence. He's not dry with any measurable amount of alcohol of his system. Number 4, that he's not drive without valid driver's license. Number 5, that he is submit to drug tests whenever so qualified by the probation officer. Number 6, that he attended and completed the residential drugs treatment program recommended by his probation officer. Number 7, that he is not associated with any known number of any gangs. Number 8, that he is not molested, harassed, or in any way communicate with his ex-wife and children. Number 9, that he performed 20 hours of community center service. Mr. Lawrence, do you understand each of every one of these terms and conditions of probation? Yes. This is sentence. Next page, 18 page. Are you willing to able abide them to the letters? Because if you are not, you have got a prison sentence hanging over your head. Do you understand? Yes, sir. That will be the order of the court then. Good luck to you. This is judgment. Judgment is should simultaneous interpreter. Next one we do a simultaneous lesson. Yeah, we did. And then number 20. Page 20, simultaneous lesson. Same time is interpreted. Assert. Defendant is accused in court for account for of the information of having committed to the crime of assert. a violation of section 240 of the Penal Code. Every person who, with the general criminal intent, makes an unlawful attempt, coupled with the present ability to apply physical focus in case this sentence family or DA does not agree. In case every person who with a general criminal intent to make an unlawful attempt, coupled with the present ability to apply physical focus, physical force upon the person of another, is guilty of a crime of assault. In order to prove such crime, each of the following elements must be proved. Number one, an unlawful attempt to make apply physical focus upon the person of another. Two, at the time of such attempt, the person who made the attempt had the present ability to apply such physical force. And number three, the person making the attempt had the general criminal intent, which in this case means that such person intended to commit an act, the direct, natural, and the probate consequence of which, if successfully complete, would the application of a physical force upon the person of another. To constitute an assault, it is not necessary that any actual injury be inflicted. However, if an injury is inflicted, it may be considered in connection with the other evidence in determining whether an assault was committed, and if so, the nature of the assault. Burglary. Defendant is accused count 5 of the information of having committed the crime of burglary, the violation of section 459 of the Penal Code. Every person who enters any structure with the specific intent to steal, take, and carry away the personal property of another of any value, and with the further specific intent to deprive the owner permanently of each property, or with the specific intent to commit a felony, is guilty of the crime of burglary, is violation of Penal Code section 459. It is immeasurable It is immaterial whether the intent with which the entry was made was thereafter carried out. In order to prove such crime, each of the following elements must be proved. Number one, a person entered the structure. Number two, at the time of the entry, each person had the specific intent to steal and take away someone else's property and intended to deprive the owner permanently of such property, or three, such a person had the specific intent to commit a felony. That one is the one line you read, and then one line you make your country word, your target language, your country language, your target language, one by one. Practice. That one is so important. One by one, if you're ready, so easy you can do interpreter, easy way. Number 21, simultaneous lesson, rape of non-spouse. Non-spouse meaning not my wife, and then rape of non-spouse. Defendant is accused in count 6 of the information of having committed the crime of rape, a violation of section 261 of Penal Code. Every person who engages in an act of sexual intercourse. Every person who engages in an act of sexual intercourse with a female person who is not the spouse of the perpetrator accomplished against such persons will be means of force, violence, of fear, of immediate and unlawful body injury, is guilty of the crime of rape in violation of Penal Code section 261. In order to prove such crime, each of the following elements must be proved. Number one, a male and female person engaged in an act of sexual intercourse. Number two, the two persons were not married to each other. Number three, the act of intercourse was against the will of the female person. And number four, such act was accomplished by means of force, violence, or fear of immediate and unlawful bodily injury. Any sexual penetration, however slight, constitute again engaged in an act of sexual intercourse. Proof of ejaculation is not required against such a person's will, means without the consent of the female person. Rape of spouse. His spouse, and then also rape is available. His wife or rape is available. Defendant is accused in count 7 of the information of having committed the crime of spouse's rape, violation of section 262 of the Penal Code. Every person who engaged in an act of sexual intercourse with his wife, accomplished against her will by means of force or for fear of immediate and unlawfully body injury to her or another person, is guilty of the crime of spousal rape or violation of Penal Code Section 262. Lewd act with the child. Lewd act with the child. Defendant is accused on count A of the information of having committed the crime of lewd act with the child, violation section 288 of the Penal Code. Every person who willfully and lewdly commit and lewd or lascivious act, open or with the body, or any part or member thereof, of a child under the age of 14 years with the specific intent of allowing, appearing, or gratifying the lust of passion or sexual desire of such a person or of each child is guilty of crime of commit lewd or lascivious act upon the body of child of violation act section 288 of the Penal Code. A lewd or a lascivious act is defined as any touching of the body of the person under the age of 14 years, age specific intent to espouse, appeal to, or gratify the sexual desires of either. That one is, you should do one by one. One by one you review, and then to your target language, change for the interpreter one by one. First time is not easy, and then after that, so easy you can translate any language to target language. Interpreter, that's so easy, not difficult, so easy. You should do one by one.